Jim Gottstein, the Executive Director of the Law Project for Psychiatric Rights.
Thank you very much, Al. Can people hear me okay? I'm very pleased to be here, and thank you all for coming. He mentioned I'm with the Law Project for Psychiatric Rights, and we being mainly me at this point, which is one of the problems, but a public interest law firm whose mission is to mount a strategic litigation campaign against forced psychiatric drugging and electroshock. And as Al mentioned, we've made drugging children and youth a priority, and Al, I think, gave a good preview of a couple of things I'm going to say. But to set the stage, I think it's really important to recognize how truly horrific these drugs are. There's been a six-fold increase in the rate of disability where mental illness is listed as the reason for disability since the introduction of the so-called miracle drug Thorazine in the mid-1950s. Now, I don't think that all of that is due to the drugs. I mean, I think the welfare to work and under the Clinton administration, the first Clinton administration, had something to do with it, but I think the vast majority of it is the drugs. This is maybe an astounding statement, but I think it can be supported, which is that the drugs cut the recovery rate from 80% to 5%. I'm going to go through the evidence on that. They're causing a massive amount of harm. I mean, people, the physical illnesses to the point where the people in the public mental health system diagnosed with serious mental illness are now dying 25 years earlier on average than the general population. And this compares to, in the early 1900s, David Healy from Wales, I think it is, he did a study of people in the early 1900s who were in the hospitals or asylums, and they had normal lifespans. And what you see is when Thorazine and the other phenothiazines came into use starting in the mid-1950s, the longevity got decreased 10 to 15 years, and then with the introduction of each generation of drugs, and especially now with the newer neuroleptics like Abilify, Risperdal, Seroquel, Zyprexa, those are really even more harmful. And this pervasive polypharmacy where more than one drug is being prescribed. I mean, you hear of people on a dozen of these things, and they all contribute to physical damage. So this all ends up being hugely and unnecessarily expensive. I mean, we've got 75% of the people that are being basically put on disability, and and their lives are being subsidized, paid for by the government, whereas if we allowed them to get through what they were going through, they'd presumably have jobs, most of them, and paying taxes rather than receiving public support. And then, of course, the human toll is just massive and is hard to describe. I mean, even people before they die when they're put on the neuroleptics, so many of them, the vast majority of them, really have greatly diminished lives. So that's kind of the setting for it. I highly recommend these two books, Anatomy of an Epidemic by Robert Whitaker. I suspect a lot of people here have read it. How many people here have read that? About 3/4. How about Deadly Psychiatry and Organized Denial? It's written by Dr. Peter Gurcha. Do people know about the Cochrane collaboration now called the Cochrane? Well, it's I think maybe the most respected evaluator of medical research. And it's independent, it has thousands of people. And he's one of the founders of it, and he's also the founder of the Danish Cochrane Center and has been running it ever since. He's been I think published 70 times in the Big Five, like the New England Journal of Medicine and the Journal of the American Medical Association, British Medical Journal, those, and cited over 15,000 times. And this is a no-holds-barred account of what psychiatric drugs are doing. I mean, he's, I don't know if it's typical of Danes, but he's very straightforward. He doesn't mince words. Okay, so I highly recommend that book as well as Anatomy of an Epidemic. So these are this is just a graph that shows the increase in the rate of disability-based, where people are listed as mentally ill since 1955 to 2007. And then this is where I'm going to get into the recovery rate. Now this is the open dialogue approach that was founded by Jaakko Sekula, I don't know if I said that right, in Lapland. And if you see that basically with a selective use of neuroleptics, and I want to say that Ron Unger, I think, aren't you going to be talking about the open dialogue approach later on, that there's a 79% of people don't have symptoms 5 years at the end of 5 years. And so that's where I'm getting the 80% recovery rate, basically. And one of the things you find is the Soteria project, which was a study of the National Institute of Mental Health in the 70s, basically had the same results. And they had a selective use of neuroleptic approach, and they got the same, pretty much the same results, 19% regularly maintained on drugs during the follow-up period. Okay. So then, this is a study by Harrow and Job. And what they did is a naturalistic study, 15 years. They followed people who had been put on the drugs, had been on them for a while, and then some got off or tried to get off, and some stayed on them. And you can see basically that they get to basically a 40% recovery rate if they get off the drugs after having been on them, and a 5% recovery rate if they stay on them. Okay, and so that's where I say that the drugs are reducing recovery rates from 80% to 5%, and I think what this is telling us is that how important it is to try and avoid putting people on the neuroleptics in the first place. You know, I refuse to call them anti-psychotics because they don't really have anti-psychotic properties for most. I call them neuroleptics, which was their original name. And so if people have been put on them for any length of time, the odds of them recovering goes down by half. Okay, so the solutions are many. Okay, and you're going to hear about 3 of them today. I mentioned Ron Unger, Steve Morgan is going to be talking about intentional peer support, and I've been drafted to talk about Soteria. And these are all proven approaches, basically, that for people that get people through what they're going through and back on a good path without the drugs. The Hearing Voices Network, I suppose this group is pretty familiar with that too. How many people know about the Hearing Voices Network? Yeah, about 80%. So that's also another good approach. And basically peer-directed, I think, has been shown to be very effective, because people who, like myself, who have been hospitalized and labeled and drugged and all that and managed to get past that, there are a couple things that which is, I think, a lot of people here too, you know, and so you know that we relate to people, we can relate to people and say, well, we've gone through that, we give people hope, and then, you know, we have ideas, and of course we don't think of people who've been labeled psychiatrically as other than us. They're the same as us. Okay, So then I want to talk about the psychiatric drugging of children, which is, just this horror that the consequences of which I think we have no idea what's going to happen, but it's really bad. Well, we've started to see some of it. I just saw in the paper a couple days ago where they're finally talking about the stimulants leading to this opioid addiction. And Nadine Lambert gave a presentation at ISEP, I don't know, maybe 10 years ago, not quite, 7, 8 years ago, where she presented a study that showed that taking stimulants, Ritalin, as a child, quadrupled the rate of cocaine addiction or cocaine use later on. So more than 1% of youth under 18 are given neuroleptics. Now these drugs, of course, were approved for adults diagnosed with schizophrenia. There's no long-term benefit. There may be some short-term reduction of symptoms, but even that often goes away. And I would say that the benefit of the neuroleptics is really for other people. They make other people feel good. 1 in 40 are on neuroleptics. On antidepressants. 1 in 40 are on antidepressants. And antidepressants are a pathway to a bipolar diagnosis because they are activating, they cause, the Prozac Boys study, 23% develop manic-like symptoms and 19% more drug-induced hostility. And the pediatric bipolar rate soared from close to none in 1995 to 800,000 by 2003. And so once you get that bipolar diagnosis, then you get not only the antidepressants, but then you get the neuroleptics and the anti-seizure drugs, misbranded as mood stabilizers. Okay. So they're even giving 6-month-olds neuroleptics. What can be the possible justification for that? I think we used to have another name for what these infants have. Colic. So, and they used to, a long time they'd give them whiskey. I think probably whiskey was better. And the child mental health disability rate soars from essentially 0 in 1987 to 800,000 in 2011. I'm trying to get this updated. So, so this drugging of children has just become a massive problem. Okay, so the solutions are many for children and youth too. The main thing, I want to mention Module 8 of the Critical Think RX curriculum, criticalthinkrx.org. And it was funded by this organization of state attorney generals from the settlement money of the Narantan case, False Claims Act case, Medicaid fraud case. And it's this whole curriculum designed to help people decide when to give psychiatric drugs to children with, authoritative citation to the evidence and stuff. And Module 8 is evidence-based psychosocial interventions for childhood problems. And I would kind of summarize them in just a couple ways. One is to help parents be better parents, to help them raise their kids. There's so many pressures on parents, single parents, both parents working, children need attention and they're not getting it and they have problems. Poverty is a problem and causes problems and all that. And so one thing is to just help the parents. We have this kind of, it's starting to be called medical kidnapping, child snatching of, child protection agencies, rather than help parents, raise their children. They just take them away. And sometimes children are taken away if the parents do not drug their children. And, you know, and so anyway, it's awful. And then the other part is to help, excuse me, help children be successful. You know, it's one of the things that they have to learn, and so that's what helps with you know, childhood misbehaving, is help them be successful, help them deal with their problems. Okay, so now I'm going to switch to some of the legal stuff. So the hallmarks of procedural due process are meaningful notice and a meaningful opportunity to be heard by a neutral decision maker. So meaningful notice means basically you have the right to be told what the charges are against you, or what's being alleged against you. And so you have, you know, there are these proceedings called ex parte proceedings, where people go to the judge, it means without notice to the other side. And there are some exceptions to the notice requirement. The classic one is a search warrant, where if you gave the person that you wanted to search notice that you're going to, you know, search him or her, then whatever, if they had something, you know, it would disappear. But there has to be really good reasons to do away with it. But meaningful notice and a meaningful opportunity to be heard, which basically means the right to give your side of it, and you have to, and you're supposed to have a neutral decision maker. Okay, then there's the substantive due process. Now, if you have a fundamental right, a fundamental constitutional right, the government can infringe on that right only if there's a compelling state interest and it's the least restrictive or least intrusive alternative. Or another way they phrase it is that the means used to achieve it are narrowly tailored to the goal. So involuntary commitment is a deprivation of fundamental rights under fundamental right under both the U.S. and Alaska constitutions. And forced drugging is probably a deprivation of the fundamental right under the U.S. Constitution and is under the Alaska Constitution. The U.S. Supreme Court, especially in United States versus Sell, I think I get to it, goes through the analysis that sounds a lot like this analysis. So that's why I say that. Okay, now involuntary commitment is permissible under the U.S. Constitution. I mean, I think there's a big question now, why should someone be allowed to be locked up if they haven't committed a crime, right? I mean, there are all kinds of people, dangerous people, you know, so why just because you're accused of being mentally ill does that mean you can be locked up? Well, as a constitutional matter, the Supreme Court says that you can, but it's got to take place pursuant to proper procedures and evidentiary standards. So when I talked about procedural due process, those rights have to be honored. And there has to be a finding of dangerousness either to oneself or to others. So that people here are very used to the idea that someone has to be a danger to self or others, and that's, you know, what the U.S. Supreme Court has said. Where that proof of dangerousness is coupled with the proof of some additional factors such as a mental illness or a, quote, mental illness or mental abnormality. So that's the constitutional justification for doing it. I mean, when you look at the research, the correlation between a diagnosis of mental illness and dangerousness is very, very slight, if any. I mean, far more predictive is you know, whether someone has, you know, is abusing drugs. Okay, so, and then the Supreme Court has also said being unable to take care of oneself can constitute danger to oneself if it rises to the level of being incapable of surviving safely in freedom. Okay, so I talked about this United States Supreme Court case about forced drugging. Now, one of the things that one should keep in mind are the different contexts in which this issue comes up. In United States versus Sell, it was a Medicaid fraud case, and he was a dentist and was accused of Medicaid fraud. So it was a criminal case, and they wanted to drug him to make him competent to stand trial. And the Supreme Court said, you've got to, in order to drug him, you have to, there must be important that important governmental interests must be at stake. Okay, well that sounds like the substantive due process compelling state interest. That the forced drugging will significantly further those state interests. In other words, will it actually make the person competent to stand trial? And that, I think, is a really dubious proposition. I mean, you remember Jared Loughner? He was the person who shot Gabby Giffords. And you read some accounts of him in court, and they tried to drug him, and to make him competent to stand trial, and he was successful in resisting that for a while. And you'd have accounts of him being in court, being very disruptive, and so they couldn't proceed. And so then, after they finally were able to drug him, they said, oh, now he's competent to stand trial because he sat at the defense table for 8 hours without bothering anybody. Well, he was just so sedated that he couldn't do anything. Doesn't mean he was competent to stand trial. And the forced drugging has to be necessary to further those interests. And that the court must find that any alternative, less intrusive treatments are unlikely to achieve substantially the same results. So that sounds a lot like substantive due process. Okay. And it has to be medically appropriate, i.e. in the patient's best medical interest in light of his medical condition considered on a drug-by-drug basis. Okay, so when you put all these together, my view is that you can't really prove that drugging someone against their will is in their best interest, and that there's no less intrusive alternatives. And so that really that it's unlawful, that people's rights not being lawful. In other words, that nobody really should constitutionally be drugged against their will, I think. Now, I think in terms of involuntary commitment, that no more than 10% of the people that get involuntarily committed actually meet the commitment criteria. And so, from my perspective, the problem isn't so much that the laws are bad, it's that people's rights aren't being honored. And so, how do we address that? And so, we've come up with this three-part approach. We call it the transformation triangle, even though it's not a triangle. And I hate the word transformation because it's been co-opted. But anyway, it's the best I've come up with so far. So the idea is that these three areas, public attitudes or public education, strategic litigation, and other choices, interact with each other synergistically in a way to change the mental health system. So let me explain. And the public attitudes is at the top for a reason, which is it's the most important thing. Okay, so let's go down on the left side. If people understood that, if the public understood that these other approaches like open dialogue, hearing voices, intentional peer support, soteria type approaches, other community-based approaches for people in the community were far more successful without the harm, then you would see public support for those approaches, right, in terms of funding. Okay, so, and one of the ways that you can change the public attitudes is by providing those alternatives and then demonstrating to the public what I just said, because they don't understand that. And that's why it's so important that we have alternatives and then go publicize that. And the publicizing is very hard because of the sway that the pharmaceutical industry has over the media. Okay, going down on the right side, or the left side, the right side. So one of the, I mentioned that only 10% of the people that get committed meet commitment criteria, and really that the drugging is not in someone's best interest, and there are less intrusive alternatives. So why aren't those rights being honored? And the reason is that basically the judges and the lawyers assigned to represent the respondents or the people facing these forced striking orders believe if this person wasn't crazy, she'd know this was good for her. And therefore, we're not going to let their pesky little rights get in the way of doing what she needs to have done to her. And so to the extent that you change public attitudes and make people realize that it's not in their best interest, it is harmful, then people's rights not to be drugged will be more likely to be honored. Okay, going up the other way is a little bit harder to see. I mean, how does strategic litigation change public attitudes? The example that most readily comes to mind for me is Brown versus Board of Education about legal segregation. Before that case in 1954 that found that segregation was unconstitutional, the U.S. Supreme Court had said that separate but equal was constitutional. And there was a wide swath of the American public that really believed that. There were lots of people that didn't, but wide swaths of people, the U.S. Supreme Court had said that. And so, that was a pretty widespread attitude. But since Brown versus Board of Education, I think that has dramatically changed, and there's only really a very small percentage of people that believe that legal segregation is okay. And so that's an example. We've actually had some success, I think, going back the other way, publicizing some of our legal cases in Alaska. Okay, so down at the bottom, one of the, and Al mentioned this in the introduction, is that people have the right to a less intrusive alternative. And the way that it's phrased, if it's for commitment, it's a less restrictive alternative, and for forced drugging, it's the less intrusive, is the way that they phrase it. Okay, but people have the right to a less intrusive or less restrictive alternative. And as he said, it's not a question of it has to be there. I mean, the state cannot infringe that right if they could provide it, and the Supreme Court on forced drugging said, if it's feasible, they have to provide it or let the person go. And so, but the problem is that it's very hard to get a court to say, okay, we're not going to lock this person up that we found dangerous, or we're not going to drug this person because of some theoretical less intrusive alternative that I can't actually send the person to. So it's hard to get them to honor that. And so to the extent that you actually have these alternatives or other choices for people to go to, that makes it far more likely that you can get people's rights to those alternatives honored. Okay, so that's kind of the theoretical framework. Now, one of the things that PsychRights has done is we have a forced drugging defense package that people can download, and it's got a couple of affidavits, and you can get original certified copies of the affidavits from MindFreedom if you're a member for a nominal fee, but I mean, they'll work with people. And it has it basically has a generic set of pleadings. It's called a motion for summary judgment, a motion for stay on appeal, that people can use. And they've been pretty popular. I think probably there have been a couple hundred of them that have been used. I haven't really heard of them being that successful. Now, there's also Dr. Peter Gurcha has a new affidavit, and you can get these on PsychRights website, psychrights.org, download them, but you can get the originals from MindFreedom. Okay, so the purpose of strategic litigation is to force the system to honor people's rights. Now, one of the things, and so just vigorously trying to enforce someone's rights is a very good thing. It changes the path of least resistance. So it's so easy for the hospitals, the state, to get commitment and forced drugging orders that it's the path of least resistance. They don't have to talk to anybody. They say, we want you to take these drugs. Oh, you don't want to? We'll make you. And they get court orders. I was talking to Dr. Toby Watson last night, and he's watched some of them, and he says First, that the lawyer often gets a stack of files right before the hearing and maybe has a minute to look at it before he goes to trial, and that maybe the hearings last 5 minutes. Well, in the Myers case, which I'll talk about in a little bit, it was a 4-month all-out legal battle, the likes of which the Alaska Psychiatric Institute had never seen before, and they didn't like it. And shortly after that, I'd gotten a call from someone who was in the hospital, and they had to file a petition. He was on a 72-hour evaluation hold. They had to file a petition the next morning in order to hold him longer, and I let them know that I would represent. I said, I don't think he meets commitment criteria, and I'll represent him if you file a petition. And they tried real hard to find something else for this guy, and I never met him. Because literally, as I was driving up to the hospital, they were driving him away to something else. I think because they didn't want to do that. Now, I recently had a case that really went on 6 weeks, and including a 5-day trial. And instead of the normal 15 minutes, it was 5 days. Now, we lost it, which we shouldn't have. You know, putting them to that kind of proof and making it that difficult for them is a very good thing in itself. Okay, so, you know, the other goals are to substantially reduce, if not eliminate, force, and then compel these other choices, alternatives. And of course, it has public education potential as well. Pat?
In some of the mental health hearings, they're using alternatives as being other drugs, and which are persuading the courts and the doctors and the psychiatric patients to be more guinea pigs to take every new drug that comes out, because if they haven't tried this one drug yet, they can be forcibly tried because they haven't tried this drug yet. And then when they're switched from one drug to another, they're doubled up on the drugs because they're not weaned off on the one drug. It's added before the other drug is, and so that contributes to the polypharmacy that occurs.
Yeah, in fact, in this case, they were saying, well, she had very bad results and reactions to the drugs before, and they said, well, she's never had Latuda before, and so then that was, so they made her do that. Okay, switching to drugging children. So it turns out that most drugging of children and youth is unconstitutional, in state custody and foster care, is unconstitutional, because basically the state has the obligation to protect children once they take custody of them. And then this is a couple of cases, DeShaney versus Winnebago County. Anyway, I mean, it's a very bad case. People think of it as a very bad case because it was a case where the state discharged this child to the father, who was known to be abusive, and then the child was harmed, and the Supreme Court said, well, the state doesn't have the obligation once it's discharged the child, but it did say while in custody they do. And then there's this recent case from Texas where the U.S. Federal District Court in the Southern District of Texas held that the state is obligated to protect children and youth in custody from unreasonable risk of harm. You don't even have to have the harm. Okay, so then the Medicaid fraud. So, you know, we should be bringing cases. We would love to be bringing cases about children in custody.
Do the pharmaceutical companies help finance the opposite side's attorney representation as a way to prevent their product from being portrayed as a risk of harm?
I don't think that they've never really been challenged. I don't think this has ever been brought up. But what the drug companies do is they're involved in, educating, with continuing medical education or whatever. I mean, all of the the various players. I mean, you go to child protection agencies and they have drug company sponsored seminars on, on the drugs. Okay, so, Julie?
Yes, how is forced drugging defined?
It's, drugging, making someone take drugs that they don't want to.
I mean, when you say a person is forcibly drugged, are we referring to only to this forced commitment to do an injection, or are we talking about a person being behind locked doors, say, being coerced, or use of threats? You must take this drug or else, or we won't let you go unless you get on this drug. That is forced, but does it fall under the definition of forced drugging in legal law?
Well, forced drugging is, I use it in legal briefs, but they kind of don't like that term. But I use it where someone is subject to court order.
Court order.
Okay, but there are these other forms of coercion that, just as you mentioned, where people say, well, if you don't take the drugs, we won't give you housing, and we'll throw you out of housing, or we won't give you services. That's very, very typical. In fact, I'd say it's almost universal in the mental health system, is that you have to be on the drugs to really participate. But I'm not talking about that. I'm talking about, but it doesn't necessarily require an injection. I mean, because a lot of people under court order will take the oral medication, but not because they want to, because they've been ordered to, and oftentimes because they don't want to be injected, that they've been tackled by 4 people and held down and stuck and drugged. Okay. So Al also mentioned this Medicaid fraud. It turns out that Medicaid coverage for outpatient drugs is limited to what's called medically accepted indications. And so and off-label prescriptions are covered only if they're supported by one of 3 specified compendia. So we have on our homepage and on our Medicaid fraud page, we have this chart of medically accepted indications. So basically, we've put together a chart of 50-some drugs to show what's a medically accepted indication and what's not. And there's some arguments at the margins about what is or what isn't, quote, supported by one of these compendia. But the at least a majority of the drugs, psych drugs prescribed to children, are not for medically accepted indications. So, for example, you see Seroquel being diagnosed for insomnia, for sleep, a lot, even to children. Well, that's not a medically accepted indication, and that's Medicaid fraud. Okay, so in the Seventh Circuit case, which Dr. Watson was here for a minute, it was his case. He brought the case. The Seventh Circuit, oh, there you are, okay. The Seventh Circuit agreed with Dr. Watson, that when a doctor prescribes to a Medicaid patient, they're knowingly causing a claim to Medicaid for that prescription. And they said that, and they held that if it's not for a medically accepted indication, it's not allowed under Medicaid, and therefore it's a false claim. Now, in another, if a prescription is not for a medically accepted indication, and that's another way to put it is it can be, if it's on label, it's medically accepted. But if it's off label, it can only be a medically accepted indication if it's got support in one of these drug references called compendia. And if it's off label and not supported by one of these compendia, then it's Medicaid fraud or a false claim. And each prescription carries a minimum penalty of $5,500. Each false claim carries a minimum penalty of $5,500. So any prescriber worth his or her salt would have done 1,000 of these in the 6-year statute of limitations. And so that's $5.5 million bucks. And the idea of this initiative is to, to tag one or more of these doctors or other prescribers and really, scaring the shit out of everyone else to get them to stop. Al?
Just might explain what off-label means. Maybe people aren't off-label.
Well, off-label, the FDA approves drugs for specific uses, and that's called on-label. There's this big, long document that they call the label, and they say, and it will say what uses the FDA has approved. And if it's not one of those approved uses, it's off-label. Now, off-label prescribing is very common, but Congress said we're not going to pay for it unless it has scientific support. And this is ignored. I mean, in fact, in the Ninth Circuit case that we had, they essentially ruled against us, saying, well, if the government doesn't care, why should we? And there's a specific, one of the provisions is called the public disclosure bar, and so that was what they hung it on. But basically, and it was a non-precedential ruling, but that's basically what they said. Julie?
Yes, with Medicaid, no, they have separated, no, some people have this Medicare Part D, is that, which is, I know the funding, everything, these laws also apply to that Medicare Part D?
It does apply to Medicare.
It does, okay.
Yeah, I mean, we were talking about the other end of the age spectrum,
Yes.
but where it's really kind of, I think, ripe for someone to do something, if we could get lawyers, is especially the elderly in nursing homes who are given neuroleptics basically to keep them from complaining or, causing trouble. I mean, maybe there's people are agitated and stuff like that too sometimes. But basically, the neuroleptics carry a black box warning for the elderly, and they double the mortality. Steve?
Another quick question. So is the Medicaid say we won't pay for this off-label just with children, or with anyone?
No, it's everybody. And it's Congress. It's Congress in the statute that says that. By the way, I've kind of abandoned the no questions, so feel free. Yeah, Congress has, that's what the statute requires. And CMS, the Centers for Medicare and Medicaid Services, totally ignores it. In fact, there was a study, or what is it, a report that talked about Medicare and psychiatric drugging of elderly. And basically, CMS said that they had no authority to enforce that restriction. And there's no support for that. It's like, where does that come from? That's absurd. Go ahead.
I'm speaking on Monday morning to a bunch of judges at the state hospital with the PAMI, Oregon PAMI group. What does this, the Seventh Circuit thing, you talk about Medicaid, but what kind of, it doesn't seem like Medicaid has much jurisdiction under the state hospital medication prescription, does it?
I'm not entirely clear about the hospital. I know that they're not really covered under Medicaid. They get some other funding, and the idea was, and there's some effort to try and change that they wanted people not to be, they wanted to encourage people to be let out of the hospitals, and so they did that through Medicaid funding. So this applies to outpatient prescriptions. Okay, I don't know if, I'm just about out of time. I don't know if we want to go through Alaska or not quickly, or.
In terms of recommendations, what to do?
Well, I mean, the recommendations, I think, are, do the alternatives. We've got to really try and get more lawyers, and we've really got to try somehow find a way to bring this to people's attention. To change people's public attitudes. Yeah?
I was wondering if you're going to talk about the case that you mentioned that had been lost recently and some of the obstacles to winning that case.
Are you talking about the Medicaid fraud one?
Yeah, you said it was...
Oh, the one that I lost?
Yeah.
Well, it was a jury. Let me just put it this way. It's now on appeal. It's this LM case. And we had testimony from someone, the psychiatrist that helped us get Soteria Alaska going and was there the whole time. And he testified that Soteria Alaska would have been perfect for her, but the state had, but it had closed due to lack of sufficient funding. And so we're appealing on that point, on exactly the point, that Al mentioned, that, and the judge said, well, I can't make the legislature appropriate, for this particular alternative, and that's not the legal point. The legal point is you can't lock someone up if you could provide a less restrictive alternative. And so we're actually, we established that in the Myers case for drugging. If there's a feasible, less intrusive alternative, they have to either provide it or let the person go. But they haven't specifically ruled with respect to commitment, and that's what this case is about. And then I'm hoping to, bring more cases and try and really put pressure on the state. Well, I'm pretty much out of time. You want me to?
Yeah.
Say? Okay.
Say goodbye.
Goodbye.